The perception of some practitioners is that Justice Panganiban also is willing to look into the context of his decisions, the impact of his decisions, but will extend more into accommodating business.
If he is as good, if the one more senior is as good as the others, well, I think he should be the one chosen.
What is the system of appointing people in the Supreme Court? If changes would be made, that's one very vital thing that we have to look into.
This is not an ordinary office. We're speaking of the head of a separate branch of government.
This is Tonight on ANC, and you are watching an exclusive one-on-one interview with the new Chief Justice of the Supreme Court, Artemio Panganiban. I would never have imagined these terms that I am about to speak, but somebody had asked me to ask you to define exactly what kind of Chief Justice you will be as a supporter or promoter of the existing Constitution. The words are constructionalist as against interventionist as far as the present Constitution is concerned. Are you going to be all-out protector of the present wordings of the Constitution?
You know, the word interventionist or constructionist are of American origin. In the United States, during the Chief Justiceship of Earl Warren, and this was many years ago, more than 50 years ago, there was a great debate as to whether the Supreme Court of the United States should be liberal or conservative in its approach to civil and political rights. Earl Warren, who was appointed Chief Justice outside of the Supreme Court of the United States, he was governor of California, was hoped by Dwight Eisenhower, who was the president at that time, to be what they called a conservative justice, meaning that he will just allow the executive department, the president, and Congress to do what they want to do and just concentrate on resolving what we call the ordinary litigations, criminal cases, commercial cases, civil cases, family affairs. But at that time, Mr. Chief Justice Earl Warren became what they called a liberal. And he was assisted by justices like Douglas, like Brennan. But as against that, you had also about 4 justices who were conservative, led by Mr. Justice Frank Porter.
Okay. So you believe in a Supreme Court that is entirely Philippine style?
Yes, we have a Supreme Court that is Philippine style. That there are Supreme Courts all over the world that are different from each other because they have different constitution and different laws. They must live within their own constitutions and laws.
How would you define the Supreme Court Philippine style?
Well, the Supreme Court Philippine style now was born out of the ashes of martial law. You see, during martial law, the Supreme Court was regarded as timid, as complacent, as passive, and it allowed several actions of the executive, meaning Mr. Marcos, to go unchecked. That is why when the new constitution was drafted by the Constitutional Commission in 1986, Chief Justice Roberto Concepcion, was already retired at that time, took lesson from this and thought that the Supreme Court must become activist, meaning that it must intervene with the affairs of government. So he put in a phrase or a sentence there, making it the duty of the judiciary, not just of the Supreme Court, but of course, ultimately of the Supreme Court, to strike down grave abuse of discretion by any office or department of government, including the presidency and Congress. And so far, our Supreme Court has been performing that duty. Note that I say duty because the Constitution says it is the duty of the judiciary to strike down grave abuse of discretion. It is not just a power. A power can be relinquished, can be waived, but a duty cannot be evaded.
There are many controversial and big cases pending now in the Supreme Court. But allow me to venture into the possibility you will actually give us an answer to this question, since it has not been forwarded to the Supreme Court yet. There are questions about the definition or the legal arguments surrounding the issue of whether 3/4 of the vote of Congress actually means just the lower house or the entirety of Congress, including the senators. Is there a way by which you can allow us into your mind about this issue?
Frankly, I do not have any idea right now. You see, judges are there to judge only after both sides have presented their cases or causes, their arguments. We cannot form an opinion about a legal question before the arguments are put in. Otherwise, we will not be judges. A judge must wait for the parties on both sides to present their arguments. And only after all arguments have been exhausted should the judge issue an opinion. That's the basis for what we call the sub judice rule. That's the basis for respecting the objectivity of judges. So please pardon me, I will not venture any opinion. I can only venture an opinion after I have heard all sides.